Good afternoon, everyone. As President of Victim Support Europe, it is my great pleasure and honour to welcome you to our debate, The Future of Justice for Victims of Crime, which we are holding today to mark the European Day for Victims of Crime. 32 years ago in Stockholm, Victim Support Europe declared the 22nd of February to be the European Day for Victims of Crime. This day offers the opportunity to remember those who have suffered as a result of crime. Many millions every year, children and adults of all genders, class and race, residents and visitors to the EU. This day is an opportunity to reflect on our successes, but also to explore the complex reasons that are impeding full access to victims' rights and services in contemporary Europe. From our inception, Victim Support Europe has been concerned about the impact of criminal justice and the systems on victims and their families. For too many victims, the formal justice system can cause further harm, and victims continue to complain of the negative impact that their search for justice has on their recovery. In late 2021, we commenced work on a new initiative to develop a policy paper that will explore how the system can be less traumatic and less harmful for victims of crime. We have labelled this piece as Safe Justice, i.e. a justice process that ensures that the safety and well-being of the victim is protected. Today's debate provides a platform for us to explore this concept and examine how to ensure safe justice from a victim's perspective. The programme for the next 2 hours will be organised in the following way. We will begin by hearing the experience of a victim of crime, before then moving on to a series of sessions focused on the current state of practice of our criminal justice systems. Each session will be led by one of our experts and will include live polls, kindly managed backstage by our IT technical support, Charlie, and then an approximate 7-minute expert reflection on the proposed topic. During the expert presentations, all participants are invited to address their questions in our chat function. The chat moderator, Annalise, will pick up the most burning questions, and when it comes to discussion, will pose the question. Given the time limitations of today's session, we will probably be able to answer 1 to 2 questions per session, thus 4 to 8 questions in total during the event. Please note that Leah, our timekeeper, will enforce speech times by doing a 1-minute left notice during the event. Today's event, the Conference on the Future of Europe, a citizen-led project whereby people from all over Europe have the chance to voice their opinions regarding the direction that the European Union is heading. The final part of our debate, therefore, will focus on the concrete recommendations for the EU in order to make the criminal justice system more victim-centric. Before beginning today, I'd like to just go through some little pieces of housekeeping. Firstly, can I ask all of today's speakers to mute their microphones when you're not speaking? Can I remind you all participants again to use the chat function if you have any questions or would like to share your comments. We are not in person today, so we are working with the technology we have available. And as you know, we all love to feel the love of the virtual room. So if you could want to show support for our speakers, please use the applause button or the thumbs up. It's a really good way to show your appreciation. Can I also please note for everyone that today's session is being recorded so it can be used in future. I'd like to thank you all for joining us online and sincerely hope that you enjoy today's programme and the opportunity to explore this issue. I would now like to welcome to our virtual stage our opening speaker, Levant Alton, the Executive Director of Victim Support Europe, to give an overview of the key principles of safe justice and their application in practice. Thank you, Levant.
Thank you, Jerry. Good afternoon, everyone. It's wonderful to see you all. Lots of familiar faces and lots of new people as well. I think we're 76 and increasing. So We promised ourselves we would have fewer large events, but it seems that there's a lot to discuss here, so we very much welcome all of you to be here. Before I start my presentation, what we thought we'd do is just have a quick poll. We just wanted to know who's here, really, to know your professional background. So we're just going to launch the poll, and if you can just click on what best suits you in there, and I think you can scroll down as well. We did throw in another other option as well, because we know it's always difficult to get the right people in there. Well, it's already a good sign to see so many people from the European institutions present, so we know that this could have an influence. I think we're more or less there, are we? More or less there, yeah. So I think if we just end that poll now. So we've got a really good mix of people there, right from the academic to civil society, European institutions, no healthcare sector. We will need to show them why justice is part of their business as well, and support as well. So we've got a really good range of people, which means that I think we'll have a really positive discussion today. So thank you all for joining us again. I'll move on to just really in about 10 minutes, giving you a flavor for why we are here, why we've actually decided to hold this discussion in the context of the future of Europe. And I've been asked really to explain the concept of safe justice. So before you start worrying, I'm not going to bore you with a lengthy explanation of the history of justice. I'll leave that to the professors. I mean, the explaining bit, not the boring bit. So I won't go through that, but it's just really to explain to everyone why, as Victims Support Europe, we felt that it was important to start talking about this somewhat different concept of safe justice, and what are we doing with that at the moment. So maybe just in terms of the development, well, for many years, we've all been pushing for a victim-centric justice. It's recognized and it's within the narrative of the European institutions. Many organizations talk about victim-centric justice at the national level. And that's all driven by the needs of victims, respect, recognition, support, protection, justice, and compensation. But despite 20 years now of European legislation, despite the UN Basic Principles of Justice adopted in 1985, despite organizations such as Vicering or Victim Support England existing for around 40 years, we've seen progress, but the practical implementation has a long way to go. Implementation is inconsistent, it can be insufficient, and it's not necessarily achieving the impact that it was aimed for, which is meeting the needs of victims, reducing the harm of crime. And I'm sure all of you will have heard from victims, or you've directly seen for yourselves, the experiences of victims within the justice system, experiences which leave them questioning why they even reported the crime, what's the point of the justice system, and how on earth did they end up worse off as a result of taking part in this so-called justice system, as they consider it at that point. So it's particularly damaging if victims have that perspective on justice, if we are trying to achieve rule of law and we are so reliant on victims being part of that system. And of course, I'm not saying that all of these problems are extensive across every single country and that it represents a complete systemic failure. We're not saying all victims and all victim groups have those same negative experiences. There are many positive experiences as well. But we do know that these stories, these testimonies are frequent enough to indicate that there's a serious problem in terms of how justice is functioning from the perspective of victims. And we just have to really question, is this just a matter of better implementing rights, which tends to be the go-to argument? We need more time to implement. Is it just a question of better implementing rights? Or do we actually have to rethink how we organize our justice systems, and in particular, what our objectives are for our justice systems? So that was one of the origins why we started looking at this in a different way, as opposed to victim-centric, purely victim-centric justice. And the other reason is we're anticipating multiple new or updated EU laws. We're expecting EU legislation on gender-based violence, human trafficking, child sexual exploitation, on the Victims' Rights Directive as a whole, and even on hate crime at some point, we would expect some kind of action. So we want to support the decision-making at the EU level. We want to make sure that we understand what's going wrong and why, so we can help the European institutions to work out solutions, and so we can help countries and governments to work out those solutions as well. So it means not just looking at what's happening at the in the country and in implementation, but it's actually also about looking at the European laws themselves and questioning whether they're good enough. So we're trying to understand why many victims aren't benefiting from their rights and why some justice systems seem to perform better for victims than others. So we don't have those answers yet, otherwise this wouldn't be a debate, it would be a presentation. And we recognize we won't necessarily find a single solution that fits all situations, and it's usually the case that we don't. Some of the key points I just want to quickly address in the last couple of minutes are really around some of the fundamentals, which can't necessarily be answered immediately and will probably take many years. One is around the objectives of justice. Another is around the role of victims. Another is about the commitments of governments and actors. Do they have a single vision? And also about the language of EU law, which I mentioned. So what's driven us in a large part is what we define as the objectives. What are the success criteria for justice? And what we've seen over the last hundreds of years as nation states have been developed and as they've taken a monopoly on the power to run justice systems, we've seen that the focus has been on ensuring that we find guilty people guilty, innocent people innocent, and also making sure that we're efficient in doing that. But our experience is that's not enough. If you have a victim, if you have a guilty verdict and the victim commits suicide afterwards, you cannot say that that is good justice. So what do we need to do to move that forward? And do we need to include the experience or participation or the safety of victims within the concept of justice and within the criteria by which we judge the success of justice? Because until you establish criteria by which you judge justice, which meets some of those needs of victims, then really it's unlikely you're going to make fundamental progress. The second point is around the type of system and the role, and we see that there are civil party systems, injured parties, victims, witnesses, auxiliary prosecutors. The question is, how does that affect the experience and the success of justice systems? We also have adversarial systems and common law systems. We have jury systems, and not all of these things, as we recognize, can be changed. But we should be open to examining every single aspect of our justice systems. To simply stand still is not good enough. We need to be open to change and exploring new solutions and new approaches. And that really affects the way we also perceive victims within the system. Are they mere witnesses used for the purpose of evidence gathering, or are they an integral part of the system? Have they a rightful place at the table? Are they a partner, even if maybe they're not an equal partner? Because the way that victims are seen within that system and the more integral they are to the system, it seems the better their rights tend to be respected. And I mentioned commitments, and we see fundamental differences in the approaches of member states. We see that irrespective of the types of system, the types of role that victims have, where you have a significant, clear commitment to change and to reviewing the way that justice works, you have benefits for victims. We've got the Dutch, when they were reviewing the implementation, they looked at the needs assessment, saw that there were risks around the case file system, developed an entirely new process because they recognized it was important enough for victims. We see the French government having a judge responsible for policy issues within their Ministry of Justice. We see in the UK that they are reviewing victims of terrorism policy, and they are incorporating a committee whose sole function is to challenge what they're finding. And that's a multi-stakeholder committee. These are real commitments to ensure change is made. And then when we look at EU law, we see multiple ways in which the language allows for fundamental differences which aren't always necessary, but may not necessarily help victims. we have may language. It's not obligatory. It has to be in accordance with national law. If the victim requests it in accordance with the role of the victim, it shouldn't affect due process proceedings or fair trial rights. And we're not saying those things are wrong, but when you don't define them, you create a wide opportunity for implementing these laws in multiple different ways. So that's where we are. We want to really explore this. We will be publishing a paper in the coming months to really set out some of our findings around what justice means for victims and what are some of the fundamental questions. It's a discussion paper. We know many of these questions or issues cannot be resolved immediately. It will take many, many years maybe to address questions of jury trial, for example. But there are plenty of other things which can be done. We have new legislation coming up. We hope that this debate today, further consultations will help us together to really ask the fundamental questions about our justice systems rather than simply accepting the way that they function now. Some of those issues we will look at in terms of underreporting. How do we get more victims to come forward? What are the barriers? But also how do we better inform them, support them and protect them and enable their participation? So these are the origins. I hope that you have an interesting debate. I know we've got some fantastic speakers that will really make for lively discussion, and I'm also looking forward to hearing from all of you. Thank you.
Thanks, Levant. Hopefully that has really helped outline some of the basic aspects of what we mean by safe justice and sets the context really for today's discussion. I'm now going to hand over to our special guest, Nina Fuchs, who is a survivor of sexual assault. Nina's testimony is a showcase of the structural and systematic discrimination that victims of sexual violence can encounter within the justice system. Nina, thank you so much for your willingness to participate in today's event and for sharing your story with us all. The floor is yours.
Thank you so much. Thank you for the invitation. Good afternoon, everyone. Some of you might already know me from the conference in December. So I'm trying to make this a little bit different so it doesn't get too boring for those who have already heard it. To all of you who don't know me, my name is Nina. I'm from Germany. I'm the chairwoman of a nonprofit organization that advocates for the rights of survivors of sexual violence. And the reason why I founded this nonprofit organization and also became the chairwoman is that I am a survivor of sexual violence myself. I would like to briefly tell my story. That story starts in April 2013. I was out with friends in Munich, which is quite a safe town actually within Germany. We went to a club, we had drinks, we had fun. It was a really good night. And then someone spiked my drink. I have a 1.5 to 2 hour blackout and complete loss of memory. And the moment I gain consciousness again is basically in the middle of the rape. There were 2 men I had never seen before in my life. And until today, I don't know how I even met them. The next day, my sister basically took me to the police here in Munich. That was the department that was just for that kind of cases, just for sexual crimes. But they didn't believe me. And the whole experience with the police was very traumatizing for me. It is very sad to say that it was actually more traumatizing for me than the rape itself. Because I went to the police and I thought I will get help. But what I experienced there was quite the opposite. Unfortunately, the rape drugs couldn't be found in my blood or urine sample due to the time that had passed. Also, thanks to the police that did the lengthy interrogation before going to the forensic medicine to get the samples. And along with that, there were many mistakes done in the process where they try to work on my case. And the only help I got was from victim support organizations. For example, the one organization called Weißer Ring, which is very popular in Germany, helped me a lot also to get a lawyer, so I could appear as a joint plaintiff and get access to information. And there were other victim support organizations, especially for women, that also helped me. 10 months later, they closed the case because they found DNA traces but didn't get a match in the database. But then 5 years later, through some coincidence, the alleged perpetrator came into the database, so they had the match. So my case was reopened just to be closed again half a year later with the explanation that I had a lack of memory. And yeah, that was super frustrating because I think that kind of explanation is super dangerous. If you send out this message that cases get closed just because the victim has a lack of memory, this is not what we want. And I felt treated in a very unfair way, because I thought that I had a right to get a fair trial. I know that in the context of rape and sexual violence, it's super difficult to get to convictions, but if you don't even have a trial, then obviously there can never be a conviction. And they acknowledged that I was not in a conscious state, otherwise I wouldn't have any lack of memory, and they found his DNA basically in my vagina. So until today, I do not understand why they closed the case, and I started to fight against that. I went through like the whole German justice system. The first thing was that I filed a complaint with the Attorney General's office. That got declined. Then I went to the higher regional court. They also declined it. Then I filed a complaint in front of in Germany's Federal Constitutional Court, which is really like the highest level you can go to within Germany. They also declined, and at the moment my case is in Strasbourg at the European Court of Human Rights. That was handed in 1.5 years ago, approximately. So I'm still waiting for a reaction from Strasbourg. And so far, this whole battle has cost me, I think, a bit more than 22,000 euros just in lawyer costs. And it was also quite an emotional struggle. So it was not an easy journey, and also I don't have the chance to ever have that trial that I was fighting for, because neither the European Court of Human Rights nor Germany's Federal Constitutional Court can force the prosecution to go to to court and have a trial. So this ship has sailed, and the reason why I'm still doing that is because I want to raise awareness around this topic, and my true hope is that through that we will see some changes, and then maybe in the future other people that experience the same story, they don't have to go through that. That is the only reason why I'm still doing that. So that's my story, and I've lost completely track of the time, even though I have 2 watches. Sorry for that. Can someone tell me how much time I have left?
You have a few minutes left, but please go ahead and we will make it for you. Don't worry.
Okay, thanks. That's the big advantage of being the victim. Then you get all the time you want. Yeah, what I wanted to address are actually 2 of the topics that will be in the discussion later. And the first one is tackling underreporting of crimes. So obviously, from my perspective, I can only speak about crimes in the context of sexual violence. So with that kind of crimes, especially with rape, within Germany, we have 85% of unreported cases. This number is from a criminologist called Professor Pfeiffer. He is the former Minister of Justice in the state of Lower Saxony. He has done some research. I think he collected data from 2012 to 2014 or 16. And this is the result he came to, 85%, which is a lot. And then there was also a study which is a bit older from German Ministry of Family and Women that shows that 50% of all rape survivors remain silent forever. They talk to no one. They take it with them to the grave, basically. And this is even more horrific, I think, this number, because every one of you can probably imagine how hard it is to live a life with such a burden and have no one to feel confident enough to share it with. So we really have to think what kind of environment are we making in our society for those kind of people, you know? And I think there is a twofold approach to tackle that. One is really to do advocacy and sensibilization campaigns in the society to raise awareness and especially to tackle victim blaming. For example, I participated in a campaign that was done by an organization here in Munich, Frauennotruf, which is for women only. And the campaign is called Speak Up. And with this campaign, we try to encourage other survivors of sexual violence to speak up and to share what horrible experience they made, just in a safe environment like this kind of organization, or just a friend or a family member, but not to take and walk through their life with that massive burden on their own. And the second important thing is really the training for all people that work with survivors of sexual violence, i.e. police and justice system. The training must concern rape myths, because there is studies that show that rapists influence the behavior of the police and how they view the credibility of a victim. They have to be trained about trauma responses and the whole topic of trauma. I think we talked about that also in detail at the last conference, how important this kind of training is for everyone that is involved with victims of sexual violence. And then in general, I think they need some training just on empathy to really understand what kind of people they have in front of them, and that they have actually experienced something really terrible, and not like I was treated as if someone had stolen my wallet. So, and some last concluding words to not like ruin the whole schedule. About ensuring victims access to information, support and protection throughout the criminal justice process. Information is really key, and information would have actually prevented the trauma I experienced with the police. I'm 100% sure of that. But that means that the information process has actually to start before the criminal justice process starts. So people need to know that there are organizations that help you, that you don't have to go to the police on your own, that you can have a company that goes there with you and kind of holds your hand. So that is important. And those kind of awareness raising campaigns have to be like all over the city. They have to be in public transport, on public transport, and on billboards in the street, that everyone knows I can get help. I'm not alone. And then also really important from my point of view is the video interrogation. I know many victims of sexual violence that had to repeat that interrogation process in this whole criminal justice process like 5 or 6 times. It is highly traumatizing and torturous for them. And then on top of that, they are prevented to get trauma therapy until the trial is like finally closed, which can also be like 3 stages in the trial. If the convicted perpetrator isn't happy with the results, so he can have another trial and another trial. And this can be a process over several years, and all those time the victim is not allowed to do trauma therapy and is actively prevented from that. That should not be the way how we treat victims and how we support them. So once you have the video interrogation, it also allows the victim to access trauma therapy immediately. So that's it from my side. Sorry for taking way too long.
Not a problem at all, Nina. Thank you so much for sharing your experience with us. I think your story really helps remind us of the reasons why this work is so important. And I think you've helpfully outlined some very immediate steps that we can take to improve the experience of victims. So thank you again for sharing that with us.
You're welcome, thanks.
We're now going to turn our attention to our panel debate, and I'm delighted to be joined by such a distinguished panel of speakers today, some of whom I know very well, which is even more exciting. First up, we have Ingrid Saunders from Belgium. Ingrid works as a confidential information officer at the ILP desk of the Federal Judicial Police at Brussels Airport. We then have Freda Weldon, who is the Development Director of Legal Affairs within Victim Support Sweden, and also a member of our Victim Support Europe board. We're also joined by Anthony Pemberton, who is a professor at Leuven Institute of Criminology at KU Leuven, and senior researcher at the Netherlands Institute for the Study of Crime and Law Enforcement. And finally, we also have another Northern Irish person joining us on the panel. He is Tim Chapman, and Tim is the chair of the board of the European Forum for Restorative Justice. So I'd like to extend my thanks to all of you for joining us today. And without further ado, I'm going to hand over the floor to Ingrid to start our first session, which is on tackling underreporting of crimes.
Good afternoon. I am honored to be here and to be surrounded by so many people sharing the same goal: a better and safer justice for victims of crime. First of all, I would like to thank Nina for her courage to share her testimony here with us today. We often forget that victims of crime are sentenced for life. Unlike perpetrators, victims have no experience at all with police forces. May too many victims of sexual violence or hate do not report the crime. This is very understandable because talking about it, let alone reporting it, is not easy. As a victim, you fear, feel guilty, are ashamed, and hope that the incident will silently disappear. Those feelings of guilt and shame are unjustified because as a victim, you have done nothing wrong. A declaration does not only support the processing process, it is also possible that the perpetrator still makes victims, or that you are not the only victim. The perpetrator is often someone you know, a friend, a relative, a neighbor, a colleague, or it can be a complete stranger. A known perpetrator will threaten the victim, what makes it even more difficult to report. And if the perpetrator is someone loved within your family or friends, who will believe you? Still, it is very important to confide in someone and talk about it immediately. In Belgium, we started in 2017 with care centers for victims of the sexual violence. Here you can find all the help under one roof. All you need to know as a victim, you find on their website. There is also a possibility to chat, to call, to mail, even anonymous. Every victim of sexual violence can go there 24 hours a day, 7 days a week. At the care centers of sexual violence, a victim will not only receive medical and psychological care from the start. Forensic nurses and doctors will also do a forensic investigation by determining injuries and examining traces of the perpetrator. Collecting evidence in the first 72 hours is very important in case a victim wants to file a report, because after 72 hours, the DNA traces are less useful. But even then, it is still advisable to have a doctor examining you. Today, the police has specially trained investigators and victim support. As a police officer, it is extremely important to listen to the victim. This might sound obvious, but in reality, it is sometimes hard to believe what the victim went through. As a suspect, you have the right to be assisted by a lawyer for free. A suspect is also entitled to have a confidential consultation with his lawyer before the interrogation. As a suspect, you have the right to remain silent or to lie. As a victim, however, you have none of these rights. You have to tell the truth in detail. This is extremely difficult. And above that, we will not always believe the victim. I will give you an example out of my own experience. I received a victim of the Brussels attack. He was in one of the cars of the subway in Malbeek, and he wanted to see the footage because he wanted to know what had really happened to him. He told me that the police had explained him during his interrogation that he had been standing in the third car, that it was just impossible that he was a survivor of the second car. the car where the bomb exploded. So I started to look for him in the third car, but I was unable to find him. It was when I started to read the report that I immediately knew that he could not have been standing in the third car. In the third car, he could not have been surrounded by severely wounded people, because there were no severely wounded people in the third car. In fact, he was standing in the second car, in the one that had exploded. In fact, the people standing around him protected him like a human shield. None of them survived. For the police taking his testimony, it was just impossible that he could have survived. So they told him that he must have been standing in the third car. And the victim, he believed the police officer. 2 years later, when he saw the footage with me and the judicial assistant, he finally understood his flashbacks and nightmares. Nobody had believed him, not even his partner, family, or friends. But his memory was right. 2 years he had been haunted by flashbacks and nightmares he did not understand. And this man was not the only victim that nobody had believed. A testimony is of great importance in further judicial procedure. We have to be aware that false reports exist. Therefore, it is significant to ask for as many details as possible from start, even in the most difficult situations. We as investigators have to keep an open mind and to try to be as complete as possible during the interrogation. This to avoid secondary victimization and more interrogations. If we want more victims to report, we have to rebuild trust in the police and in justice. We have to let people know they will be treated with dignity, that we are there for them, that they will be accompanied by victim support during the difficult judicial procedures from the start. I thank you very much.
Ingrid, thank you. That's really helpful, and I think it really echoes some of the comments that Nina was sharing as well, and it's around that need to get messaging out to victims nearly before they're a victim, so that we understand if we do become a victim, that that's what is actually available to us, and the importance of that immediate response from particularly criminal justice agencies. I am conscious that we don't have a question as such in the chat box as yet. So I'm going to remind you all, if you have any questions, put things up in the chat box. I see some people sharing some information to research and areas of our reports that can be read. There's one there in particular around the impact of crime on sex workers and the issue around underreport in particular. I see Lev's noted up there around the need for kind of tailored responses to for a range of different victims, because as we all know well, victims are not one homogenous group, so not everyone is going to need the same thing. So that need-based approach is so important. I'm now going to move on to our next poll. Just as we're concluding this piece, and we will have a few more questions, time for questions later. So if anybody wants to ask any question of any of our speakers, please pop it up in the chat box. But I'm now going to ask everyone to participate in our next poll, which I believe has come up on the screen now. I'm working on from two screens here. So the poll is, according to you, what do you think? So should third-party reporting, anonymous reporting, or both practices be implemented to facilitate the reporting of crime? So third party being that the crime can be reported by someone else other than the victim, anonymous reporting being that a crime can be reported, but there's not necessarily anything that indicates who the victim is. I think I'm going to, have we most people in? Has everybody cast their votes? This feels now a bit like Eurovision. I'm excited. For anybody who heard us at the beginning, we were hopefully going to get some of our staff singing some songs, but that didn't quite happen. Yeah, I think we maybe end the poll there, and I'd say, yeah, the majority there are that 60%. So the majority of people who have voted believe that third party and anonymous reporting are both worthy of being permitted to try and improve the whole issue of underreporting. So I am now going to move on to our next panel speaker, who is Anthony Pemberton. And Anthony is going to reflect on the next question in our debate, which is how do we ensure victims access to information, support and protection throughout the criminal justice process? Thank you, Anthony.
Yeah, thank you very much for that, Geraldine, and thank you very much to Lev and all the rest of the gang at Victim Support Europe for organizing this event. And honored to be here, like Ingrid also said. And thanks to Ingrid very much for her input as well. And of course, thanks to Nina for making so many things so clear in such a short time that I think is important for us to reflect on today. I think my general input as to the subject of how do we ensure protection, support and rights of victims of crime. I think what we generally need to start doing is to ensure that what we seem to have as victims' rights in our respective systems actually are victims' rights. And that I think is one thing that is lacking across many European states. And what do I mean by that? Well, most rights that you have as a citizen across our countries, if they're violated in one way or another, then there's a basic requisite that there's a remedy if your rights are violated. Now, the difficulty and that's in fact something that's enshrined in our Fundamental Rights Charter of the European Union, that citizens have to have an effective remedy before a court of law in the case of violation of their rights. That is simply just not the case for most victims' rights, who for that reason should not be seen as rights at all, but as provisions that suggest something. And I think one of the things that we need to do as a priority is to start ensuring that what we actually call rights are actually rights. It doesn't necessarily mean that these remedies solely have to be individual, that people can appeal to a court of law when their rights are violated. I think there's an important avenue to be explored in collective mechanisms to enforce rights, public interest class actions and things like that. And of course, my hope is that having a right to a remedy in the case of a violation of a right means that those rights will be respected in the future. I think the case of Nina also shows very clearly that what victims in fact don't really want is to have too many legal proceedings in the aftermath of their experience. So I think as a priority, but the general sense as a priority, also to prevent violations from rights in the future, is that across European member states, there should be a remedy in the case of violation of victims' rights. That's one thing. But we shouldn't, and I think that's one thing that we all know, as people are invested in victims' rights, put our faith in the law in its entirety. The law will only get us so far. There's a large discrepancy between what the law is on the books and what we need the law to be in practice. And therefore, I think we also have to pay attention to non-judicial mechanisms. And the first thing I have three things that I think I'd like to suggest to you. The first is that European member states need to start spending more attention to monitoring of the situation of victims. I think Nina also pointed to the type of research that shows the dark number in reporting of crimes. That's something that should happen across European member states. that should be available across European member states. And that I think that many member states still have a lot to do. And so monitoring is the first thing, adequate research, adequate data to know how the extent of the respect for victims' rights. And maybe one thing I can flag up is that we're in the process of revitalizing the idea of a European victims' rights monitor, which would be an effective means to see to that. That's one thing. The second thing, I think, is funding. That might be completely obvious to many of the organizations many representatives of the organizations here, but any service delivery also starts with adequate funding for services. That can be for victim support organizations or for the type of organizations to which Ingrid referred, that particularly target sexual violence in the direct aftermath of sexual violence, a system that we also to great success have in the Netherlands as well. Those two things, I think, maybe already speak, maybe familiar to many people in this area, but maybe the most important one is mainstreaming of victims' rights. So one of the things that I see that we put too much stock in the past years is training police officers, is training prosecutors. But then in the end, what matters most is not their individual training, but their organizational goals. Victims' rights should not be some add-on to the other things that police officers get up to, or the other things that prosecutors should do, but they should be a signature goal of what these organizations strive to do. And that mainstreaming should be a part of everything that is related to criminal justice, which it simply isn't. A colleague researcher of mine at NSCR in Amsterdam, who I think is also in this session, Freda Augustijn, showed in her research, in her PhD research, that one of the things that is particularly difficult, one of the arguments that prosecutors and judges and police officers always give, is that they have other priorities that are simply more important than paying attention to victims' rights. So I think the key goal is to start shifting those priorities towards victims' rights, so mainstreaming. And then I have one final issue. I think what the tale of Nina made particularly clear is issues relating to secondary victimization as a cause of the system. But I would like to make a point about the issue of secondary victimization. I think the problem with the way secondary victimization in many of our countries is phrased is that it's seen exclusively as something that you level at organizations when they actually do something. Well, the greater problem is that they're not doing anything, or they're in fact actively prohibiting people from partaking in their rights. So the bigger issue around secondary victimization is not when organizations act, and particularly not when it's organizations or instruments that are actually for victims. I know Tim Chapman will probably have some more to say about this, but I find it very difficult to understand why secondary victimization is sometimes mentioned in the progress of restorative justice, which is an active instrument for victims, but is very rarely leveled at the fact that the large majority of victims are so poorly helped by our criminal justice systems that they won't report their crimes. Many people in the same situation as Nina will have heard their stories and will say, well, the one thing that I'm not going to do is I'm not going to report my crime. 85%, I think, was the number that she meant. That, I think, is the most important form of secondary victimization that our systems are portraying against, I think, millions of victims across Europe every single year because of the way that they frame their own understanding of their activities. And I think that's one of the other things that should be a priority of us all, that secondary victimization should no longer be targeted at victim impact statements or restorative justice, where to me, for all the disappointment that participants might have in these situations, is something that victims actively choose to engage with themselves, while involuntary for many victims across Europe, they're not being served by justice, and they omit to go to justice because of the kind of experiences that Nina was addressing. So that was my 5 cents on these issues, and I'm very eager to see if there's any questions about that.
Anthony, thank you so much. I really find your last point there actually very interesting in terms of the secondary victimization piece in particular, because we do often consider it where victims are engaging, but the actual fact that so many people choose not to engage because of what they may encounter is such a testimony to how shocking our systems must be. I am going to hand over to Annalise, who has been monitoring the chat function. Annalise, is there any questions for our speaker that you want to share? And I'll then ask any of our panel members if they want to respond.
So much, Jerry. So we actually have 2 questions, but I'll start with addressing the first one. So in terms of the legal remedies that you referred to, Anthony, in terms of violations of victims' rights, which do you think are the most feasible legal remedies? Do you think it's best achieved through fines and through compensation, or do you rather see it in a different?
I'm sorry, Annalise, I just didn't hear that last part. So fines and compensation, or?
Yes, or do you envision the most feasible remedies to look differently?
Well, thank you very much for that. I think there's a lot of ways that we can think about remedies, and there's a lot of areas of law that we can draw inspiration from. Again, it's somewhat odd to think that all these kind of things would be very familiar to people who might have a dispute with their neighbor about a fence, but are not available to people who, like in the case of Nina, being sexually violated. I think most often I would prefer what is known as superior remedies, but victims actually have an opportunity to either review or appeal where that is possible in situations, decisions that affect them. But otherwise, inferior remedies should also be available. Inferior remedies like compensation and similar things. So I would at least suggest that one good way of ensuring rights provisions is to have at least a remedy in one form or another, reasoned and fitting with other elements of the system available. And that is something that at this moment, we just talked about the importance of the right to information. There is no remedy when that right to information has been violated. There is just none. And so even if that would be an inferior remedy, I would be in favor of that.
Thank you, Anthony. I'm wondering, does anybody else in the panel have anything they would suggest in terms of legal remedies? Putting you all under pressure here. You have to earn your supper. I can't see the whole screen, but nobody else is coming up with anything. So Annalise, is there any other, did you say, was there another question there?
Yes, there was another question in relation to the funding the funding question that was raised by Anthony. So Levent asked whether the money should be put into support also within the justice system. So for instance, for court accompaniment, court attendees, preparation of victims to cope with trial, a right to a lawyer and the like. Do you think that that's also where part of the funding should go to?
Yeah, I think, of course, in the end, funding should be available where these services are most effective and through the means that they're most effective. I'm somewhat agnostic on the way that has to occur. Different countries have very different systems. The one thing I do really want to flag up as well is that funding for victim support organizations and specialized organizations, for example, for restorative justice, has the big advantage that these are also active participants in monitoring activities. One of the difficulties I see in my new home country of Belgium is exactly that a large part of the service provision is done by organizations that, or by service deliverers that are also part of other organizations, rather than a separate NGO that can also actively act as a watchdog, as a victims' rights champion. So I would say both are good, but the added advantage of funding organizations like the organizations in Victim Support Europe is that they do more than service delivery. They're also active participants in seeing that victims' other rights are also seen.
Thank you, Anthony. I'm just noticing earlier there was a question that had come up from Ingrid, and Ingrid, I'm going to put you under pressure now and just check in with you. There was a question which was, how do you think we should handle the point about victims and the obligations to tell the truth? So if you'd highlighted it in your presentation around, you know, defendants' rights to remain silent, but victims' obligation to tell the truth. Have you, this was from Levin, he's saying that we've been discussing ideas around the presumption that a person is a victim, or that they are telling the truth. Do we need to change the basic premise that victims are treated as victims from the outset? And do you have any thoughts you'd like to share on that?
Well, especially for victims of human trafficking, they will have problems to tell the truth, because for them, the smuggler saved them out of a very difficult situation. So I think it is very important not to put those people under pressure, because when they come in contact with us, they are in such a precarious situation that we should take care of them instead of putting them under pressure to tell us the truth about the smuggler and about the route that they followed and how much did they pay. So for us, it's not easy, but we will have to find another way to find the truth.
Thank you, Ingrid. Does anyone else want to come in with anything, or somebody shout if you see a hand, because my screen, I can only see the speakers at the minute, and only some of them. Right, without further ado, I'm conscious of our time. I'm going to move on to the next poll, which I think the next poll is a multiple choice question. So I think that it's kind of select from the following. Yes, so please select the correct statement below. So there you've got a hint, only one of them are true. So if you want to start to vote, so it's victims of crime have the right under EU law to be, I can't see other thing other than, oh, they're automatically referred to victim support services. The second one is under EU law. The third statement correct. All victims of crime have the right under EU law to call witnesses in the course of their trial. So the voting's coming in. We still have a few more people to vote. We're getting going the right direction. So one of them's true. Okay, I'm going to say to close the poll in 5 seconds. Oh, it's closed. So there we are, and it's coming up on the screen, and the majority, 60% of those who voted went for B, which is the correct answer. So under EU law, victims of crime do have the right to receive information after their first contact with the law. But interestingly, they don't have a right to be referred to victim support services. And not every victim, and partly this would be to do with just the type of system that's in each of the member states. Not all of them have the right to call witnesses in the course of their trial. That takes us on to the next section of our topic, which is around ensuring active participation of victims in the criminal justice process. And before we move on to our next speaker, we're going to run another poll. So fingers on your buttons again. And this is poll 4, which is: in which roles can a victim of crime participate in the criminal justice process in your member state? So either in your member state, can victims participate as a witness, as an injured party, as a party to the proceedings, or as other. And the votes are coming in for that. Okay, everybody's voting. Injured party is in the lead here. I'm not sure if everybody can see the results as I can see them coming in. It's quite exciting. But I am going to hand over, just before we close this poll, I'm going to hand over to our next speaker, who is Freda Weldon from Victim Support Sweden. Freda, we've just shared the responses there, so this is kind of a little context to setting the ground for your contribution today. So thank you again for joining us, and I'll hand the floor over to you.
Perfect. Thank you so much, Derry. And I want to add on my thanks to the organisers, of course, for this event, and for Nina for sharing your story so openly and bravely today. The responses to this poll seems to have disappeared, but if I remember rightly, it was 62% where there was a, here we go, as an injured party, we have 62%, and as a witness, 23%, and in only 15% of member states and the respondents that we have present today is the victim able to join as a party to the proceedings. What this tells us is that, as we suspected, most criminal justice processes today consists of mainly two parties. We have the state, represented by the prosecution, and we have the accused, represented by the defense attorney. Vemers used to say that if crimes truly were directed at the state and they were not committed against people, then this dual party configuration would make perfect sense. But in reality, most crimes are committed against people. And these people, the victims of crime, they seek and deserve recognition and justice for the crimes committed against them. We are across the EU today seeing a continual change in how we perceive the role and standing of victims in the criminal justice process. And we're beginning to move beyond a needs-based approach to a stronger rights-based approach, where the crime itself is actually seen as a violation of victims' rights. And even the EU directive does acknowledge that crime is a wrong against society, but is also a violation of individual rights of victims. And victims are therefore entitled to remedies and redress. How do we do that in the best possible way? That's what we're discussing here today. But what is clear in my topic of participation is that victims must be given a much better ability to actually participate and not be left standing at the sideline of the trial dealing with a crime committed against them. I will, in my submission today, identify 4 key steps that I believe will significantly improve victims' ability to participate in the criminal justice process. And the first one is related to the poll. We need to see a stronger role and standing for victims in the criminal justice process. And as we saw in 15% of responding countries, victims are able to join as a party to the proceedings. Strengthening victim standing and ability to participate and make decisions in their own case, it also gives back a sense of power and control, something that is often expressed had been taken away by the crime itself. So in addition to acknowledging the role and importance of the victim in the justice process, this is also an important step in the victim recovery. And as a key part of a stronger role, I also see the right to legal representation for the victim, to ensure that the victim's interests are represented throughout the police investigation as well as the trial. Legal representation also helps keep the victim informed, explain decisions taken in the case, and gives the victim the ability to ask questions and have their view of events expressed and explained before the court. So that will be my first point. The second key factor I think we need to see is the establishment of more court-based support. Support and information regarding the rights, the roles of victim and witnesses in connection with criminal justice proceedings. These are an important part of access to justice. Support will help the victim feel understood, calmer, and the idea is to also be able to provide their best possible evidence, which in turn, of course, give the court the best basis for their verdict. Receiving information about what to expect, how does a trial work, it also helps to limit the risk of secondary victimization, of victims being actually harmed by participating in a criminal justice process. In cooperation with a legal representative, court-based support services are also often well placed to identify needs and maybe apply for protection orders in connection with evidence statements. So this would be my second key feature to see. Court-based support being offered to all victims taking part in criminal proceedings across the EU. And information about this support could, for instance, be given as part of the citation to court. My third point deals with the training and the attitude of criminal justice professionals. We've seen countries identify different ways and different methods to create an environment in the criminal justice sphere where victims should be able to feel safe and participate in a more effective manner. This could be both in the design of the court building itself, it could be protective measures when giving evidence. During the pandemic, we've seen the rise of online trials where victims are able to give evidence from other locations, for instance. These are all really well-intended initiatives, but they are utterly dependent on individual judges' views and acceptance of these measures. Victims' rights, they don't work in theory. We can have all the victims' rights in theory we want, but victims' rights only work in practice for victims when they are applied in practice. So we could have all the measures to enable participation, but the subjective views of individual judges today often hinders the use of these well-intended measures to improve and modernize victim participation. So as my third point, I would like to see further training of the soft skills. We're talking about the respect, behaviors, the attitudes of the judiciary, and this will be required to actually enable the improved participation in practice. And as my final point, I would like to see victims' views used as a strategic aim for the criminal justice area. So we've seen improved standing, we've introduced stronger rights, but how do we ensure that victims actually are able to participate and access safe justice in practice? I would suggest that criminal justice systems should set specific strategic aims regarding victims of crime. This could, for instance, be in relation to victims feeling informed, victims feeling safe, victims feeling able to participate, justice having been served, the justice process being seen as fair, objective, whatever may be a suitable aim for the country in question. And all victims and witnesses, if suitable, having taken part in a criminal procedure, should then be able to assess whether or not they feel that in their situation this aim was actually reached and whether justice has been delivered in practice. Truly and fully implementing victims' rights to participation and to justice, it means that victims' voices are invited and acted upon. Like Anthony mentioned, the victim must be a key person also in the process about the case itself. And victim participation is a core component of a functioning and fair criminal justice system, which in turn would bring better justice outcomes, not just for individual victims, but for the criminal justice system as a whole. So those would be my key 4 messages to send along: a stronger role and legal representation in the criminal justice process, court-based support service, training and attitude of criminal justice professionals, and in this scenario, mainly the judiciary, and making victim experience a strategic aim for criminal justice. Thank you.
Freda, thank you so much. I am wondering, Annalise, I'm not sure if there are any questions in the chat function. I did have a question for you, Freda, so you're not going to get away that easy.
No.
Your last point around victim participation in the system. I'm wondering, have you come across, or is there anything in Sweden where you see that in action? Are there any initiatives that you heard of where that victim participation and their views are actively sought and have the potential to either influence or at least just be heard? Have you any examples?
Yeah. Well, in Sweden, like in many countries, every court is an independent authority. So they will do their own decision making based on their scope and remit. So we have seen some courts being better than others in terms of user feedback. And this could be victims actually feeling that they are represented, victims feeling. For us, safety is usually one of the key objective aims that the courts try to achieve. So we have some courts being better at identifying whether or not this aim was achieved. And one of the biggest criminal courts in Sweden, they have acted upon this user feedback by establishing a better setup, for instance, waiting areas where victims and witnesses don't have to sit with the accused or the accused's family. They're a bit more mindful about how victims enter the building and how they exit, how they move around in the building to minimize contact with the accused, with the aim of improving feeling of safety and ability to participate, but minimizing contact. So I would say it's down to court. Some courts are better than others, I would say.
Yeah, so those are very practical steps, which obviously can be enacted hopefully reasonably easy, whereas changes to the law obviously can take a long time. I see a question coming up on the box there. Sorry, Annalise, I'm on it. Are you aware of any good practices in Sweden of procedural accommodations for victims or victims of crime with intellectual or psychosocial disabilities?
I have a case study that my organization worked on regarding this. And for us, this dealt with the training and how to interact with the victims with different comprehension disabilities. This was a rape case a few years ago up in the north of Sweden. And this victim was, the problem with this victim was she was struggling in deciphering what was relevant and what was irrelevant information. So deciphering the information that this victim would give was the main challenge in identifying, can we pursue this case into court? Through the victim support structure that we had up in the north at the time, we were able to find an expert witness that actually came as an expert witness to the trial and provided information in terms of how this type of disability that the victim suffered from impacted on her ability to explain what had happened to her and comprehend what had happened to her. And the victim support was fully convinced that without this expert witness, this case would have been dropped due to difficulties in cooperating with the victim. In the way the questions were asked so that she could comprehend them, in the way that questions were phrased so that the right type of information was used for evidence in court. So this was a case where you can see that training in terms of this was comprehension disabilities, but it really enabled them to work with the victim in a better way.
Well,
And to enable her to actually get access to justice. And we actually saw a conviction in this case.
Wow. It reminds me, in Northern Ireland and actually in other parts of the UK, we have a special measure, it's called registered intermediaries. And their role is to assist victims with communication difficulties, and they will be involved right at the reporting of the crime, so they can assist in terms of the police interview and then also in the court itself. So their role is to assess the communication needs of the victim or witness or the accused in the case, and ensure that those communication difficulties are addressed in order to enable all parties to give their best evidence. So it does make such a difference and certainly helps, I think, with that whole access to justice piece for all. I see Lev has put something in the chat box, and you know Lev doesn't like to ask any simple questions. Lev's nice, wee difficult
I'm
questions.
sure my time is up, Jerry. I'm sure it's up.
Well, he's put it to all panel members, Freda. So if you want to say I defer, wouldn't want to hog the limelight, you can. But what Lev has asked is, do you think that all victims, irrespective of role, should have the right to ask for evidence to be collected or to question the accused, etc.? So he's referring to that these rights exist for civil parties in the likes of France, I presume. So why not for other victims around Europe? So anybody, any big button thinking on that? Anthony, I'm wondering, even from, I don't know your understanding, I know you're not necessarily a legal background, but what do you think about that?
Well, no, I mean, I know that this system exists, for example, in Germany and in Poland with the auxiliary prosecutor, the Nebenklage in Germany, and unfortunately in Poland, the word that I have a very hard time pronouncing. I think that is definitely something that could be looked into in other countries as well. My main hesitation is that I would just much prefer that in this case the public prosecutor just does his work well and informs victims and informs victims of what the steps are, and also gets victims' takes on the way that he will proceed. So if there's things that there's a particular victim interest, the public prosecutor also takes it up. And I have a sense that I prefer that to a greater degree than, say, putting victims in a position of being an auxiliary prosecutor. But to be honest, I would very much welcome more research on experiences of victims with the auxiliary prosecutor in Germany. That is something I think that could definitely also be an option.
Thank you, Anthony. I am conscious of time, so I'm going to move on to our next poll. Just before I do, I did just want to flag, just in terms of Freda's point earlier around representation and right to legal representation. Northern Ireland's actually piloting sexual offence legal representatives for victims pre-trial, so it hasn't been extended to the trial process, and that's a big step forward. We're the only jurisdiction in the UK to be looking at that, and Victim Support actually host those legal advisors, so there are lawyers there that will provide independent legal advice to victims of sexual violence, and that tends to focus around their Article 8 rights to privacy, and also around disclosure of our previous sexual history. So that is a pilot which is underway and is something that will be being evaluated in the years ahead, but it's certainly a significant step forward, I think, for victims, particularly in those type of cases, and also some of the reasons why people maybe choose not to report. They can come and speak to a legal advisor before they get to before they make actually any decision about going to the police. So I'm just going to conclude this topic and invite everyone to participate in our next poll, which is, do you think that victims should have a greater role in criminal justice proceedings? So it's a yes or a no. Oh, and it's straight in there. The yeses are going mad. So if anybody wants to object, put it in. There's an I don't know, things are starting. So a greater role in criminal justice proceedings, and it is a single choice, but unfortunately we don't have, because of the nature of the way the survey works, you're not able to put in free text. So in particular, for anybody with strong views either way, put it maybe into the chat function, so it's useful for the rest of the participants to see what's informing your choice. And I'm particularly, so I'm just serving my own interest here. I'm interested in the views of those people who don't think that this should have a greater role in criminal justice proceedings, and what influences that. So I think it's really important to get the whole breadth of the debate on this issue. So if you do feel comfortable, put something into the chat function. So I'm going to, that's the poll ended there now. So we have 84% have yes, 4% have no, and 12% have said they don't know. So again, anybody wants to flag anything, they can. Anybody in our panel, I'm looking across here, does anybody want to make any comment? Are they surprised by any of that, or does it all seem reasonable? Is there anything with anybody's hand up? Anthony, do I see your hand up? Sorry if other people are going to win. Anthony, go ahead.
Oh, maybe the only caveat, because I said yes, but maybe the only caveat is that I think that the criminal justice system as a whole should be more oriented towards victims, very much along the lines of what the way that restorative justice works. So, I mean, that's my main caveat, is that I would very much prefer the criminal justice system as a whole to be more victim oriented than to insert, to have to go for the second best option, is inserting victims' rights into a system that doesn't seem to be, seems to be victim unfriendly from the start. So I think that's maybe the only caveat that I would add.
Yeah, no, and I think that's a really interesting point, and I think it kind of echoes kind of your sentiment around the auxiliary prosecutors as well. You know, it's, do we have to twist the whole thing out of shape in order to achieve what we need to for victims, rather than just addressing the issue with the system and doing it all encompassing, rather than putting the onus on victims in that regard. Okay, thank you, everybody. That takes us to our last speaker for today. And this session is looking at the availability of reparation and remedies for victims. So our last speaker is Tim Chapman, who is a distinguished trainer and thinker in the field of restorative justice, restorative practice. Tim is going to speak on the topic of the availability of reparations and remedies for victims. Before I hand over to Tim, we have another poll. So we'd like to know whether restorative justice practices exist in your country. So the poll should now be coming up on your screen. So if you please select your answer, it's a yes, no, or a don't know. And again, throughout this afternoon, you know, if any of you have any questions for any of the speakers, please put it in the chat function, and we should have a little bit of time at the end of Tim's contribution to look at that. So I think we will maybe end the poll there. Oh, yep, people are still coming in. Oh, yep, okay. And if we share the results, so we have 65% of respondents do have restorative practice in their country, 20% no, and 16% don't know. So that's a little platform for you to kick off on, Tim. I will hand over to you.
Well, thanks very much, Jerry, and thanks for inviting me to speak here at this very important debate. It's interesting that restorative justice is growing very rapidly in Europe. Almost every country has some form of restorative justice or is intending to develop it. And for somebody like myself, who's an enthusiast in this field, it's a very encouraging and exciting time. But it also has its drawbacks. I suspect that this being, you know, a conference really about victims and people who work with victims, that there'll be many of you have a sort of distrust of restorative justice. And you would be right to, as far as I'm concerned. While research generally states that victims are usually, you know, highly satisfied with the restorative process, you know, the research quotes percentages like 85 to 90%. Of course, that means that there's 15 or 10% who are not satisfied, and that's not good enough. Recently, I did a little bit of research into restorative justice with young offenders and found many instances where victims' rights were abused and victims' needs were disregarded, mainly because the organization delivering restorative justice was an offender-centric organization, and its systems, its values, its priorities were all oriented towards the offender. So we still have a long way to go before we have a truly victim-centric restorative justice process. But this is what European Forum for Restorative Justice, which I'm involved in, is committed to. We're committed to high quality restorative justice, and that means putting victims at the center, their rights, their needs. I'm also involved in research into victims of serious crime who've experienced restorative justice. And indeed, I'm a practitioner. I'm working on 2 major projects of institutional abuse, institutional sexual abuse by organizations, faith organizations, on both young people and adults. So a lot of what I have to say is to do with sort of practical and research experience of victims. Just want to make a few points. Firstly, that restorative justice takes harm very seriously, particularly the harm suffered by victims. Part of my research was listening to a woman whose daughter had been killed by a drunken driver, and she described in great detail her meeting with the perpetrator who was in prison. And I've never heard anybody describe an accountability process as rigorous as she put that perpetrator through. She challenged and asked him to justify every decision that he took that night that ended in the death of her daughter. And she herself found that, quite relieving of a lot of the suffering that she was experiencing. So we take the harm of victims seriously and look at it rigorously. We also take the importance of listening to the voice of victims and to actively supporting their participation in the decision-making through a restorative process, whether it's mediation, conferencing, or other variations of that. So I think, we're on the same side as the sort of victims movement. And I really liked your sort of new approach, safe justice. In my country, in the sort of British context, we tend to always emphasize safety over justice, and I like the combination that you've chosen, because not all victims are afraid. Not all victims are seeking safety. Many are, and many are very grateful for protection. But some victims are angry, not fearful about what happened, and are seeking justice to satisfy that anger. Some victims feel shame. As it was mentioned earlier on, they have no reason to feel shame, but nevertheless, our society is a very shaming society. And in my research, I find shame plays a big part. And one of the benefits they find from restorative justice is this sense of validation and vindication you get by facing your perpetrator. And often what they say they've been relieved of is that sense of shame. They no longer feel ashamed. But most of all, what victims have told me that they need out of restorative justice is to regain control. Crime is the imposition by one human being over another of their, imposition of their power and control over another human being for selfish ends. And unfortunately, as we've seen already, that the criminal justice system tends to reinforce that lack of power in the victim, and so do families, friends, even. And this is the main thing that I think good restorative practice does as a remedy to this lack of power and control. Best practice will put the victim center and will pay attention to what they need and their choices throughout the whole process. The victims that I've spoken to are welcome and are grateful for compensation, and many of them are very happy that their perpetrators have been punished. As I say, I'm talking with people who have been victims of serious crime, and usually there is a prison sentence. But they all say, every single one of them, that getting compensation, having the perpetrator punished, is not the end to their suffering. They continue to be dominated by the aftermath of the crime. And sometimes what they need to do is meet the perpetrator, tell their story, emphasize the impact of his actions on their lives, ask questions, and make requests of the victim. This can relieve that sense of anger, shame, fear, or whatever they have, that anxiety that their life has sort of spun out of control since the crime. And in that way, restorative justice can provide remedies and reparation, not necessarily material reparation. Often the reparation is more of an existential or emotional healing. In the best practice, I think the victim is enabled by the practitioner to co-design the process. Because restorative justice is basically the victim and the perpetrator of a harm in a room together with a skilled third party to talk about what happened. And that, of course, nobody feels totally comfortable with that process. So I think best practice is to engage the victim co-designing that process in saying where it should be, when it should be, how the room should be organized, what the process should be, who speaks first, who speaks next, how many people should be in the room, how many supporters can they bring, a whole variety of things that they should be engaged in deciding how they can create a space in which they can be brave and tell their story, ask their questions, and make their requests. So to sum up, I think restorative justice does help the victim understand what's going on a bit better, supports them through a process, and provides them with some repair of the damage that crime has caused. I think it can also be extended to some of the abuses of the system. One of the things I was asked to talk about is what are the remedies when the system causes further suffering to a victim? And I think I would again recommend first protocol, some sort of mediation. Because in that way, the victim has the satisfaction of saying what they want to say in their words of their choosing, and being listened to. And the benefit to the system is hopefully they do listen and they learn and they slowly develop the attitudes I think everybody here wants, a greater sense of understanding of what a victim needs, what their rights are, and how they should be treated by what is a highly bureaucratic and professionalized system. So thank you very much.
Thank you, Tim. I am struck when you're speaking just how much, when you're describing the process of restorative justice, how participatory it is, and how that stands in stark contrast to what we in many member states experience in terms of the formal criminal justice systems. And I do find it interesting to think of how that restorative piece as well could help shape the criminal justice response through that learning and inviting victims and witnesses to share their experience of that system and how that can be improved. I don't know if there's any questions, Annalise. I'm sorry.
So we have a question on a lack of balance and a lack of equality of arms between the perpetrator and the victim, but that's more in justice proceedings. So I believe that's more a question to all panelists and not just simply directed at Tim. Okay, so does anybody have any response they want to do that? So it's a lack of balance, equality of arms between the perpetrator and the victim in the justice proceedings. Perpetrator's power comes from the presumption of innocence. Could that be responded to by a presumption of victimization? So I think this echoes maybe one of the comments from earlier, is there? Does anybody want to jump in? I see there's another one come up, from Lev. There Lev goes with his difficult questions. But I don't think this one's too difficult. But Tim, this is more focused on restorative, so it's for you. So are there any types of restorative justice or situations where you think that restorative maybe shouldn't be used or wouldn't work?
My simple and maybe oversimple answer to that is when the victim doesn't want to do it. If I meet a victim who wants to meet the perpetrator, then my job is to make it safe, make it effective, whatever the crime is. And my research has shown that some of the most horrendous crimes, I mean, really serious sexual crime, domestic violence, killings, attempted murder, that there are some victims who want to meet the murderer, because that person is the only one who can answer the questions that keep them awake at night. There is nobody else. And that is the terrible tragedy of crime. So I wouldn't discount any crime whatsoever. Like Jerry, I come from Northern Ireland, and I have seen, terrible terrorist atrocities. And I have seen victims wanting to meet the person who did that, because they just have these existential questions about why would something so terrible happen? Why was I chosen? What is the meaning of this? And they need to tell their stories as well. So I would say I would not rule out any particular crime or situation, but what I would be guided by is, does the victim want to do it or not?
Yeah, I think I certainly would agree with you on that one, Tim. I suppose the only bit I would add on to it is that the victim is fully supported to make that decision, and that there's no pressure on the victim to feel in some way that they are rehabilitating the perpetrator by participating. So as long as that's an active engagement to meet the victim's needs, then obviously all the relevant safeguards and training and whatever needs to be in place as it is for all processes. I am conscious there's another one here which is
Are there any type of restorative justice or situation where it shouldn't be used?
I'm wondering, I'm not sure where that came, who that came from, but I think that was the answer. Maybe there's a delay. So Tim has just answered that question from his perspective, saying in cases where the victim doesn't want to. The one question I was going to just ask you there, Tim, which was linked to, you may have a view, particularly with the European Restorative Justice Forum hat, is how can we consider the incorporation of cross-border victims in restorative justice?
To be honest, I haven't really thought about that question, and we should be thinking about it, particularly in Europe. I think obviously there'll be complications. I think, where there's a will, there'll be a way, because when I was working as a practitioner, we would have got sort of requests from, the south of Ireland or from England, because the victim or the perpetrator was living in Northern Ireland. Now, generally, those are sort of neighboring countries, most of which is in the same jurisdiction, so that simplifies it. But I suspect it's possible to do cross-border restorative justice. But to be honest, it's not something I've really thought about in any depth.
Okay, thank you. I'm going to draw this wee bit to a close with a final poll, which is poll number, I'm losing count of my polls, poll number 7. So this question is, do you think the right to access restorative justice services should be guaranteed for all victims of crime? Okay, the votes are coming in, where yes is in the lead so far. I'm not sure if all of you can see this as it goes, so apologies if you can, and I'm doing like a racing commentary, which is boring you all. Okay, we'll draw to a close maybe there now, and then I think we can end the poll and share the results. If that's coming up on people's screen, you'll see that 83% of respondents said yes, 8% no, and 9% were unsure. So that takes us to really the last section of our afternoon's debate. And thank you all for your participation. I think we have another poll to come, so don't take your fingers off those buttons yet. But as we come towards the end, it's really just time to think about some final conclusions from the debate. And as I outlined at the beginning, we're hoping to come up with some recommendations to the EU in relation to how to improve justice services to protect victims of crime. So I want to really ask each of our speakers to come up with 3 key takeaways on what they think the EU should do to improve justice services to protect victims. So some of you may have already outlined these in your panel contribution, so I will not ask you to choose other ones if you don't if you don't have them up your sleeve. But if there's any sort of key 3 points. So if I hand over to Ingrid first, maybe.
Well, we have to think about free legal support for victims. I think that's a right. And to make the step to report as small as possible, and therefore an implementation of care centers where you can find all the help under one roof would be very big improvement. And training. I think as a police officer, it is really important to be well trained and to be aware of the problems of victims and how to deal with them. Thank you.
Thank you, Ingrid. And now I hand over to Anthony.
Yeah, I think I did indeed already answer that in my earlier intervention, but that rights should be rights. So that they should be backed up, be enforceable, and should be have remedies. I made the point about mainstreaming victims' issues into all kinds of policies, so that's a priority. And I also made the point about the access, the issue of secondary victimization as being a larger problem when the system doesn't react. But maybe the most important thing is that I think that on the longer run, the system should be reoriented towards the principles that underlie restorative justice. Otherwise, we remain tinkering around the edges rather than putting the victims at the heart of our reaction to crime and victimization.
Thank you, Anthony. And Freda.
Thanks, Jerry. I've been scribbling here because I've been changing my points as others have been stealing them. I would like to add something that we haven't discussed yet, is access to support to the EU to introduce a mandatory referral requirements with an opt-out focus, so that all victims are automatically referred to support services unless they wish not to be, as opposed to today where we have quite a vague idea of we can facilitate referrals, but it doesn't really have to happen. And we need to differentiate between informing about support and actively referring to support. Those are 2 very different things. So I would strongly support a mandatory requirement for a referral in an opt-out setup. I would also like to comment in relation to the fragmentation of the victim debate that we're seeing both nationally and internationally, where we are dividing the victim discussions into smaller and smaller groups, specific groups of victims in this area, specific rights in that area, which makes it a more challenging debate, and we're starting to almost rank needs and rank priorities as opposed to enabling access to all rights for all victims. And I think this is one of the strengths for the EU directive, is it covers all victims of crime. So I would really love to see that maintained in an updated directive. I really wish to see a strength for all the rights for all victims, and continue to have a tailored approach to needs with the individual assessments, actually identifying the needs of victims, as opposed to assumptions being made based on crime type or personal characteristics. That's my second point, and I think I should also stick to my trauma-informed criminal justice, ensuring that we pick up what Nina was saying in the beginning, that we're still very much seeing rape myths. We're seeing the image of the ideal victim being used by our criminal justice professionals. Any victim, for instance, we've seen quite a lot of research in victims expressing emotions being seen as more reliable than victims who are perceived to be too calm when they report their crime or give witness statements in court. So the challenging of the ideal victim model and ensuring that we have a better understanding that victims are individuals. Everyone will react differently, and we can't dictate what will be a more reliable response than not based on the idea victims. Better knowledge and understanding of the impact of trauma and crime on victims would be my third comment. Thank you.
Thank you, Freda. So yeah, that whole individual response, whereas if all victims have access to their rights and greater participation in the system, but if all of our practitioners are trained to respond in an individual tailored way to meet their needs, yeah, it's key. And Tim, lastly, not least, I'll hand over to you for your three. I think you're on mute, Tim. I had to say that one throughout today, so well done.
Yeah, I never learn. Firstly, that all citizens throughout Europe should have access to high quality restorative justice when they choose, when they need it. Secondly, that I think every European country, and I'm not familiar with your sort of business as much as I should be, but every country should have strong victim support organizations who will support, inform victims proactively rather than reactively, and I would hope would mention the availability of high quality restorative justice as part of their service. And finally, I think the European Commission should give a lot of money to Victim Support Europe and the European Forum for Restorative Justice to develop a high quality, victim-centric restorative justice model accompanied by strong standards of quality that would be enforced throughout Europe. Thank you.
Thanks, Tim. Now that was very specific, not only what we want, but who's going to deliver it. And there's Anthony clapping as well. It's all good. I am, Annalise, I'm not sure if there's any questions in the chat function, and I'm just going to encourage you all, if there's any 3 points or 1 or 2 points that you would like to make and add your vote to please do so in the chat function. And that is starting to take us towards our last poll. So anything they want to add in, please stick it in the chat. But it takes us to our last poll, which is kind of wrapping up where we all began earlier. As Lev said, it seems an awful long time ago, but it was only almost 2 hours ago, that this is a discussion. And it's an ongoing piece of work for Victim Support Europe in terms of developing this and the whole notion of safe justice. And it will be a policy discussion paper. It won't be a paper that will have all of the answers. But if there's certainly a lot of the ideas that have been shared today in both our panel contributions, Nina's contribution, and also the contributions that participants have made in the chat function will be saved as well and noted down for influence in that paper. So our final poll then is poll number 8. I love how I speak and then something happens. It's like if only that happened in real life all the time. And there it comes up. So do you think the European Union should adopt a safe justice approach to their criminal justice work? And the votes are coming in on that. And again, I suppose it's that safe justice concept is kind of what we're discussing earlier. Really what we mean is that it causes no further harm to victims, and victims can engage in a way with it without causing further harm or trauma in that regard. So I'll let the poll run for another few seconds. I note Freda's just added another point in. So Freda, were you trying to put in a fourth point after saying your three?
I did. And I'm just going to steal the moment now as well, because we're waiting. The witness plays such an important role in equality investigations. I would just really like to see stronger rights even for witnesses, not just.
Yeah. And then I'd say there's a point there around gender sensitive narrative in the chat function as well. And victims should not have to go to all instances and then no international level. So really the role of the European Court of Human Rights being highlighted there and the impact there. And I hope everybody can read through some of those chat pieces. There's nothing else that is jumping out at me. And I think we're going to stop the poll and share the results. So there they're up. So we have 87% saying yes, 2% no, and 11% saying I don't know. So interesting. I'm always intrigued by the ones who are not sure or don't know the yes stuff, because again, I think sometimes our language and our understanding of things is really important as well. So we want to make sure to get as much stuff as possible. I see a quick question there, Freda, and I'm really going to very quickly just hand it over to you. Oh, there's two. Oh, right. I'm going to do two more questions and then I'm going to sum up. One's for Tim and one I think is for Freda. So Freda, can a witness be viewed upon as a victim when the event was traumatic to experience? And how should they enjoy the principles of safe justice? I think you've probably touched a little bit on that, but if there's anything more you want to add in terms of that witness role.
Absolutely. And I think it's in this aspect important to differentiate between the role in a criminal justice proceeding and the impact that an incident may actually have on a person. So many witnesses are quite traumatized by what they're actually seeing and need support and the ability to actually address the impact that experiencing this will have on them. We have many examples of first responders, for instance, attending scenes that will be seen as direct victims as well. So yes, but in the criminal justice proceeding, that will be very much down to the national setup, of course. The way Sweden is currently working with this, we have a new legislative proposal about to be proposed, where the police would have a responsibility to inform victims and witnesses. We have an information responsibility to inform victims of support services, but that also witnesses should be informed of support services when they're first in contact with the police. And we're hoping that that would, of course, enable them to feel safe and secure enough to share their story, what they have experienced, and also engage with the criminal justice investigation in a more effective way.
Thank you, Freda. The other thing I would just note as well is in Northern Ireland, we have something called a victim charter, which is placed in statutory legislation, which is rights and entitlements for victims of crime. But we also have a witness charter, which is yet to be placed in statutory legislation, but covers the entitlements for witnesses of crime as well, which is really trying to address some of those needs as well. So I think there's a lot of good practice out there that could be further developed and enhanced. And very quickly, Tim, I'm going to do a last question for you because there's a few questions come up around RJ there, which is, do you think that there's any risk in attaching restorative justice processes to formal criminal justice processes, or should they be kept totally separate?
I am on, yeah. There are risks. There are risks in working within a sort of very traditional, hierarchical, conservative system and trying to maintain the values of restorative justice within that system. I've always worked within the criminal justice system, so I remain an optimist that the system can be reformed and become much more responsive, not just to victims, but to the community and to people who offend, rather than just trundling along at its own pace, according to its own priorities. I think this is where standards are important and rights are important, because if you can get the standards of practice and the rights of victims and of perpetrators right, you can create a sort of protected space for restorative justice, even within a very powerful system that doesn't share all the values. So I still remain optimistic that it's possible. I think there are examples of very good practice throughout Europe of restorative justice within criminal justice in places like, Belgium, Norway, and Finland, and Germany, Austria, and from in my own country, Northern Ireland. But it's a struggle. It's a struggle. There's no doubt that the values and priorities of a criminal justice system constantly threaten to invade the space that ordinary people need to talk about the harm that they've experienced.
Thank you, Tim. I think from my perspective as well, I think one of the key things with that is the time that sometimes is then, so time limits and deadlines that is sometimes put in place in a formal traditional criminal justice system, which really kind of doesn't quite work in the restorative piece, where you need time to reflect and consider and make informed choices, as opposed to being under a limit set by a court or whatever. But definitely possibilities and positives that can be achieved. Okay, I'm going to draw this to a close.
Jerry, you're on mute. Excuse me, Jerry.
Sorry. Don't know if you heard anything what I just said there. I was just trying to make Tim feel better for his mute earlier. So it's a Northern Irish thing, we just do that. But I was waffling, so don't worry about me, but it does take us to a close. And I want to thank all of you today for your participation. I particularly like to thank Nina and our panel for sharing their expertise with us, as well as our behind the scenes staff for ensuring that I'm being heard when I'm supposed to be, and that the technologies worked, and also that we all managed to be here at the same time in the same online space. Today's debate showed the importance really of intersectoral cooperation to develop and maintain a comprehensive justice system that is less harmful to victims and also victims' families. I think the discussions emphasise the role that all sectors of our society must play in supporting victims of crime throughout the criminal justice proceedings. As always, it's great to bring different individuals together, and it really highlights how essential it is to collaborate. I think by working together as agencies, we can provide services and develop systems that are more efficient and effective than what they would have been if those agencies or services acted alone. So the advantages really that offers with regards to criminal justice partnerships is clear. Really, bringing together different perspectives and complex problems, ensuring mutually beneficial understanding, achieving cost savings through better efficiency should all ensure that we develop a more joined up and effective criminal justice system, which, if it's better able to focus on justice for victims and families, will hopefully then deliver safe justice for those victims and their families. We've heard of some good examples and solutions, and also some questions. And as Lev said at the beginning, it is a discussion. It's not the final product as yet. And our job really is to expand on these ideas, increasing our knowledge and disseminating really what we've learned, particularly from across the different countries and different professions and experiences. And significantly, I think, needing to hear from victims and survivors themselves of their experience of the system and how that should shape it. During the year ahead, Victim Support Europe will be working explicitly to clarify the laws, policies and practices to better support the victims that we represent. And we'll continue to raise the public, professional, government and also victims' awareness of the work that is being carried out to provide victims with access to safe justice in their time of need. We look forward to continuing to collaborate with you on this journey. And I suppose I'd like to thank you all once more for your active participation. I hope it's both been informative and inspirational. I certainly have enjoyed the last couple of hours, and I'm going away buzzing with lots of thoughts and ideas. So thank you all. Take care.
Thank you.